It gives me great pleasure to welcome you here and to chair this particular session. I've noticed members of the diplomatic corps being here, government departments, including the Department of International Relations and Cooperation, also the UP administration, including our Dean, Andre Bourain. He has to leave early. NGOs and practicing lawyers. I think I've seen members of the Southern African litigation unit here, the litigation center here as well, and academics, of course, from different faculties, also different universities, and students who are, in spite of their exams, are able to be here. So we're delighted to have all of you here today. We started organizing this event only 2 or 3 days ago. And I must say that I wish that the interest of our students in some of our lectures is as pronounced as having you here today. And of course, we give the students a year advance notice and make it compulsory for them to attend. We do like to think of the faculty as a place that hosts this kind of event and allows for a responsible, critical, creative discussion on issues of the day. And of course, today we see as a primary example. I would like to thank Johan, Pretoria, al-Rapporteur for many of the arrangements that they've made. The events are being recorded on video and will be available on the website of the Institute and the faculty, as well as on podcast. I think in future we'll do live streaming of these sort of events. And let me just say that there are vouchers for tea or coffee afterwards available. So if you do not have them yet, in the kiosk afterwards, you can just exchange the voucher for a tea or a coffee. And Johan and the others have copies of those. So if you don't have it, you can just come to the podium and get a voucher. And then all of you are welcome to join us afterwards if you have time for further discussion. Let me just tell you a brief story by way of introduction. As those of you who follow legal history will know, the High Court in Pretoria gave a judgment against the government of the day. The court claimed to have the power to test the actions of the government again under the Constitution. The president of the country took exception against this approach by the court and said that the testing power of the court came from the devil. He then fired the Chief Justice. Now, I'm not talking about recent events. I'm talking about something that happened more than 100 years ago in Pretoria with a clash between Paul Kruger and Chief Justice Kotze. If the approach of that court was followed at the time, most of the laws of the old Zuid-Afrikaanse Republiek would have been invalid, all kinds of political consequences. In a way, it brings the question to the fore what the role of the political consequences of judicial decisions should be and whether they should be taken into account. The events of a few days ago and the ongoing events have some resonance with what happened then, but the issues raised are obviously much broader. Our debate, and indeed the debate today, is about the legal consequences of the decision by the South African government to allow the President of Sudan, who has been indicted by the ICC for war crimes, crimes against humanity, and genocide into the country, and in spite of a court order to allow him to leave the country again. This may bring a number of legal obligations into play, and that's is in essence what our debate is about. On the global level, our obligations under the UN Charter, the ICC Statute, and possibly the Genocide Convention. On the regional level, the Constitutive Act of the African Union, and possibly the African Charter on Human People's Rights. And on the domestic level, our obligations under the South African Constitution and the ICC Act of 2002. Our main concern today is the nature of these legal obligations. Did they require a different approach from the government, or are they to a greater or lesser extent in conflict, allowing the government the space to take its own decisions? Much of the debate so far has been in sound bites, but I think today Johan and Dira will develop the finer nuances of the possible different approaches to this question. And I think what we are trying to do then is to establish really behind what is said in the news lines, to what extent on the legal basis can one say there's a clear legal obligation, or to what extent is it perhaps not as clear as it seems. I will invite responses from the floor to these issues, in particular the legal matters, but I think the broader issues cannot be ignored. And I think it will also come to the fore. We cannot ignore the potential conflict between our country's legal obligations and our political obligations. But it's also a question, what are our obligations on the political level to Africa? Are these obligations primarily to the political leaders or to the people of Africa? And I think that will also come into play. The issue under discussion brings in the starkest possible way questions about the future of our country and the continent, and indeed the international system. into focus. Will and should South Africa leave the International Criminal Court? And Frans Viljoen has recently written something on this. So Frans, you also has to leave early. But I put a number of copies of his, I think, very thought-provoking paper on this topic here. It's also on the website of the Center for Human Rights on this issue of staying or leaving the International Criminal Court. The issue of accountability is at stake. In this case, accountability for the most serious crimes imaginable at the highest possible level. The way in which this issue is dealt with now will have far-reaching implications for accountability and the rule of law in future. How are we to understand these events against the background of the collapse of the SADC court and the distant possibility of an African court on human and people's rights with criminal jurisdiction? Is the primary problem what the consequences would have been if we arrested Bashir when he was at the AU summit, or is it why did we allow the situation to arise in the first place? At the same time, the argument that Africa is often at the receiving end of a system of international justice that we did not design in the first place cannot be ignored. And I hope this will be explored in the discussions. The implications of arresting a sitting head of state, for which there is not really an international precedent, should also be considered. And I think this really sets the stage for a very interesting discussion to follow. We're very fortunate to have two outstanding South African international lawyers here with us today to participate in the debate. And as a faculty, we're very happy to have them here. One of them has been my professor, one of them has been my student. I leave it to you to work out which one is which one. There may be, as they say, different shades of grey in place here. But that is certainly not their main claim to fame. Johan van der Vyver is one of the top legal minds that South Africa has produced, an authority in fields as diverse as property law, jurisprudence, constitutional law, human rights, international law, and in particular, international criminal law. He has published widely and has participated in the international processes concerning the International Criminal Court. He's a professor of law at Emory in the US and extraordinary professor in the Department of Private Law at the University of Pretoria. And we are delighted that he happens to be in Pretoria and to be with the University of Pretoria precisely at this time when this issue arose, and that we ran into each other in the quad and started talking about the issue, and that we decided to have this debate. Tladi is one of the best students that this faculty has produced. He has held academic positions at UNISA and at the University of Stellenbosch, and he is now a professor of public law in the University of Pretoria. He has served for many years as a legal advisor to the South African mission to the UN in New York. He's one of the youngest members of the International Law Commission, where he plays a leading role. He serves as legal advisor to the South African Minister of International Relations and Cooperation. He sits in the office next to me, and we've had many beers, not only here, but in New York and in Geneva, and it's always a pleasure to hear his informed views on matters of international law. So we're delighted to have these two speakers, and then afterwards the opportunity for discussion. I will ask Johan to make the case that there has been a violation of obligations, and I will ask Dira then to respond. So thank you very much.
Thank you for having me and for listening to me. Let me begin by saying that there are three reasons why the South African government was compelled to arrest President al-Bashir. First of all, because there was an order issued by the Security Council of the United Nations acting under its so-called Chapter 7 powers. Decisions of the Security Council under Chapter 7 of the Charter of the United Nations are obligatory. States of the world are compelled to execute them. And so the fact that the Security Council instructed the states of the world to cooperate with the International Criminal Court in bringing al-Bashir to justice means that we are compelled to do so. The second reason is because South Africa is a state party to the Statute of the International Criminal Court. The functioning of the International Criminal Court is to a large extent dependent upon state cooperation. The provisions in the ICC statute that deals with state cooperation falls into two categories. Some are conditional, one is unconditional. The duty to execute a warrant of arrest and to surrender a suspect for trial to the ICC is an absolute duty not subject to any reservations. So South Africa is compelled to execute the warrant of arrest. There's no exception to the rule. The third reason is because South African law provides that South Africa must comply. After we ratified the ICC statute, Parliament adopted Act 27 of 2002, which laid the framework for the South African government to comply with its obligations as a state party to the ICC statute. Article 3.1 and 3.2 of the Act makes it quite clear that it was enacted so as to create the framework for full cooperation of South Africa with the ICC, and Article 8 of the Act laid down the conditions, the procedures that have to be followed in order to execute a warrant of arrest. So South Africa is clearly legally obligated to arrest him. In the second week of June of this year, what's it, 2 weeks ago, the South African government approached the pre-trial chamber of the ICC in The Hague because they wanted to host the conference of the African Union, and the African Union would not hold a conference in a country that does not guarantee that they will not arrest al-Bashir. But since South Africa was legally obligated to do so, they asked the International Criminal Court for guidance. I have the judgment of the pre-trial chamber in my hands. On the 13th of June, the pre-trial chamber explained to the South African ambassador in The Hague and a South African legal representative that was also present, and also present was a representative of the prosecuting office and of the registrar's office, and the pre-trial chamber explained to the South African government that there are no problems of controversies. South Africa is under a legal obligation to arrest al-Bashir if he comes to South Africa. In spite of the fact that the rule of law required the South African government to arrest him, there's also a court order that was given to this effect of the High Court of Gauteng, also instructing the South African government to hold him in the country until finality could be given by the court as to his arrest. And in violation of that order, in contempt of court, our government decided to give him free access, free exit from our country. Who is al-Bashir? I described President al-Bashir as the Adolf Hitler of Africa. Al-Bashir gained political power by unconstitutional means. And he set himself a task to create a Sudanese people that are almost exclusively of Arab extraction. The province of Darfur, which admittedly constitutes a large part of the country, is mostly occupied by African tribes, 3 major tribes and a number of smaller tribes. So in order to create a Herrenvolk, as the Germans called it, God's people of Arab extraction, he allegedly gave instructions for members of these African tribes to be slaughtered or driven out of the country. And according to some estimates, more than 3,000 Africans were killed by him. I mention this because I find it disgusting that our government would afford protection to a man whose alleged crime consists of the slaughtering of fellow African tribesmen so as to establish a predominantly Arab state in Sudan. And you might also know that not so long ago, President al-Bashir also gave the blessing to the establishment of a secessionist state, Southern Sudan, that seceded from the state of Sudan Why? Because their population is predominantly Christian, and he wanted to be rid of them. So I can find no justification for not arresting him, especially in the circumstances of the acts of genocide of which he was accused. Now, the African Union in the past have launched certain points of critique against the International Criminal Court, largely in two categories. First of all, they lamented the fact that the trials before the court all emanate from Africa. Let me emphasize that trials can be brought before the ICC through a state party referral, through a Security Council referral, or through the prosecutor conducting an inquiry in proprio motu based on reliable information. There are at the moment 8 situations from which prosecutions emerged. 4 of them were referred to the ICC by the government of the African country concerned. That is the situation in Uganda, in the Democratic Republic of the Congo, in Central African Republic, and in Mali. The governments of those countries requested the International Criminal Court to investigate the allegations of criminal acts that were committed. 2 of the situations were referred to the ICC by the Security Council of the United Nations. That is the situation in Libya and the situation in Darfur. And let me just say in passing that the United States, for one, vetoed all Security Council resolutions that even mention the word International Criminal Court. And that's a whole debate as to why that was the case. But the United States did not use its veto to prevent the investigation into the allegations of wrongdoing in Darfur and in Libya because of the very seriousness of the crimes. 2 of the situations were referred to the ICC following an investigation proprio motu by the prosecutor. Both of those cases, the one in Kenya and the one in the Ivory Coast, the prosecutor was requested by the governments of those countries to conduct that investigation, so that all the situations relating to Africa, except for the 2 referred to the ICC by the Security Council, was requested by the governments of those countries. And let me also just say that you must remember that the ICC functions on the basis of complementarity, so it cannot investigate or prosecute a crime if the national state does it itself. It, for example, is investigating a situation in Colombia, but the government of Colombia said, leave it to us, we will prosecute, investigate and prosecute. The second big complaint that was brought by the African Union was the fact that al-Bashir is a sitting head of state and therefore enjoys sovereign immunity. That argument is totally ill-founded. Since the Nuremberg tribunals, it has been established that sovereign immunity does not apply to prosecutions in international tribunals. Sovereign immunity is part of state sovereignty. So if a person enjoys sovereign immunity, he cannot be prosecuted in the courts of his own country or of the national courts of any other country. But it has been established time and again that sovereign immunity does not apply to prosecutions in international tribunals. The so-called arrest warrant case of 2002 of the International Court of Justice confirmed that by way of an obiter dictum. But the Special Court for Sierra Leone confirmed it by way of ratio decidendi in the case of President Charles Taylor. Charles Taylor, when he was brought to trial in the Special Court for Sierra Leone, raised the defense that he is entitled to sovereign immunity, and the court decided that sovereign immunity does not apply to prosecutions in international tribunals. And Article 27 of the ICC statute is based on the same principle that sovereign immunity is no defense cannot avoid prosecutions in the International Criminal Court. That's Article 27, paragraph 2 of the ICC statute. So the point is that the arguments advanced by the African Union in critique of the ICC is totally unfounded. Let me just make a final observation that the rules of procedure and evidence of the International Criminal Court is the best of all in the whole world. It put together the best of all the different systems of the world to have a system of almost perfect justice. For example, in the International Criminal Court, you might have been taught that ignorance of the law is no excuse. In the ICC, ignorance of the law is an excuse. In many legal systems, if you raise a special defense, you bear the burden to prove it on a balance of probabilities. Not in the ICC. The South African delegation proposed, and it was accepted, that there will not be a reversal of the burden of proof. So if you raise special defense, the prosecution must still prove beyond reasonable doubt that this is not true. If al-Bashir is brought to trial in the ICC, there will, as soon as possible, be a confirmation of charges hearing. And the court will only go forward with the case if there are substantial reasons to believe that he has committed the crimes with which he is charged. 2 people from Sudan who were indicted to stand trial surrendered to the court voluntarily, and in both cases the court did not confirm the charges and they were discharged. So this is not a problem raised by the ICC, by the African Union, but everybody knows that this is a very, very good system designed over many, many years so that people will not have immunity from these very, very serious crimes, such as genocide, which is committed still in many parts of the world. And so I also just want to mention that the International Criminal Court is not only a court of law. It has a special department that provide medical and psychological treatment to the victims of these crimes. They've spent tens of thousands of rand and dollars in Africa to assist the victims of child soldiering and the victims of rape to be treated and reintroduced into the civil community. It's a wonderful institution. Do not undermine it because you want a man who is guilty of murdering, or allegedly guilty of murdering African tribes. You don't want to let him go off scot-free. Thank you.
Thank you. We had a very spirited and a fast introduction from Johan's side. Thank you very much for that. We're honored and privileged to have Dire to give us his view on some of these aspects. Thank you very much.
Thank you very much. That was indeed a spirited introduction to our discussion. I'm going to avoid the broader issues. So I'm not going to talk about the targeting issues. I see a couple of my friends from the ISS. I normally give lectures for them and their groups on these issues about whether or not, in fact, there's targeting. I want to focus on the issues that we have been discussing over the last 2 weeks, and these are these issues relating to immunities and so on. Does the man have immunities? Does he not have immunities? But before I do that, I just want to take issue with a number of specific points that were made in the very rousing introduction. The first one was about the nature or the character of Bashir. And I agree with you on most of what you said. In fact, while I was working for the Department of International Relations and Cooperation, then referred to as the Department of Foreign Affairs, within an internal magazine, I criticized the government for being party to a decision of the African Union which focused not on the legal issues but on the political issues. So the whole issues about targeting, about why all. So on those issues we agree. But that's not what's at stake here, right? The issue is not about whether or not Bashir is a good man or a bad man. I think most reasonable people can agree he's a bad man, right? That's not the issue. Then you made a point about, and I will discuss it in greater detail, but I just want to make sure that the specific points that you raised I actually respond to. Then you made a point about the Security Council and the fact that the ICC has this matter before it by virtue of a Security Council referral. And of course, that is indeed true. And you made a point, I guess referring to Article 103 of the UN Charter, that because of this, the obligations that are included in the Security Council resolutions trump all other obligations, and that's absolutely correct. And yet I challenge you to show me in UN Security Council Resolution 1593 where it says all states are obliged to cooperate. I'll tell you what the resolution says. It's paragraph 2 of the resolution. It says Sudan, that is the situation country, is obliged to cooperate. All other states are urged to cooperate. In legal language, Security Council practice, urge is a request, right? It is a request. And there's a very specific reason why there's a request and not an obligation. Okay, so that's the other point. Secondly, you said that cooperation is so important under the Rome Statute that there are no exceptions. And indeed, cooperation is very important under the Rome Statute. In fact, the ICC has been described as a giant without limbs, that it can really effectively only do what it needs to do with cooperation of states parties. So absolutely, cooperation is critical. But it isn't correct, it is inaccurate to say there are no exceptions. I note in your presentation, you didn't mention once Article 98. That's part of the Rome Statute, and there's a reason why it's there. And I'll come back to that. You also mentioned that under South African law, there is a duty to arrest, and I think you're right. There's certainly a duty to arrest under South African law. But there's also, under South African law, immunities, right? And I will talk a little bit about that and say why I think there's immunity under that. I won't discuss the issue of the High Court order and the contempt of court, because I think those investigations are ongoing, and quite frankly, as a legal matter relating to this, it has nothing to do with it. It may well be that there was contempt. I don't know. So I don't know the particular events surrounding the men's departure, but I do want to speak about the specific legal issues. So with that in mind, let me now begin with my views on the matter. And my views on the matter is that it's really complicated and nuanced. I don't take a position one way or the other. What I do say is the following. Anyone who says to you, it's simple, it's straightforward, there's an obligation, is wrong. It's not simple, and it's not straightforward, and it's complicated. There is a conflict of obligation, both at the international level and at the domestic level. That's essentially my point, right? That conflict has to be resolved. How it is resolved, I don't know. But we have to admit, if we're really being honest with ourselves, forget that he's the devil. This is not about al-Bashir. This is about the law and what the law means, right? It's not about al-Bashir. It's about what the law means. And if we are really honest and faithful about what the law means, we will accept that there is a conflict of obligation. I'll start off with the Rome Statute. You're absolutely right that under the Rome Statute, there is no immunities, right? But I'm glad that you phrased it the manner that you phrased it, because normally people phrase it incorrectly, and you phrased it correctly. In fact, if you read yesterday's judgment, it suggests that because of Article 27, there is no immunities anymore. That's not correct, right? That is not correct. Article 27 deals with the relationship between the accused, in this case al-Bashir, and the ICC. It does not affect any other relationship. So if we have an international law obligation relationship with Sudan, Article 27 does not affect that, right? Article 27 does not affect it. Article 27 deals with the relationship between the accused and the individual. What is very interesting is that everyone is relying on the DRC case. Now, you held out the decision that was made. In fact, that was something else I thought I would respond to, but perhaps we'll come back to that. You held out the decision that was made by the pretrial chamber on the eve of the whole matter, so last week Friday or last week Saturday or whatever the case may be. And of course that decision also relies on the DRC. In fact, it says there is no reason to rule on this matter because we have ruled, and then it gives you a chunk of what was held in the DRC. In fact, if you read the DRC, In fact, if you read the DRC case, the ICC pretrial chamber essentially says that Article 27, and I don't agree with this point, but it goes against what everybody seems to think it's saying. But if you read the DRC case, it's essentially saying that Article 27 only applies to officials of state parties. That's what it says. So it doesn't accept the logic that you have put forward, that since the Nuremberg tribunals, there's no immunity before international jurisdictions, right? It specifically says only with respect to states parties. Of course, then it goes on to make the argument about the Security Council resolution, therefore it actually doesn't matter, that's the point. But it takes a rather limited view of Article 27, right? Which is in contrast to its earlier decision in Malawi and Chad, where it essentially said that Article 27 does everything, right? Article 27 not only applies to non-states parties, but essentially also affects relationships between states parties and non-states parties, right? So you have the Rome Statute, and it contains this rule, but this rule, of course, relates to the individual, the accused versus the ICC, or in relationship to the ICC. And then you have, and you mentioned again, the duty to cooperate, which is, of course, an extremely important duty to cooperate. And there's a duty to cooperate here because regardless of how one interprets the interplay between Article 27 and Article 98, as you mentioned, there was an arrest warrant, right? As you mentioned, there was an arrest warrant, and in terms of Article 98, Article 98 does not bestow a right on a state. It bestows a duty on the Office of the Prosecutor or the ICC. It says you may not request cooperation if the request would require a state to act inconsistently with its obligations under international law. Now, the fact that there was a warrant of arrest and not a single state party said, hang on, you are acting inconsistently with the statute on this, that is sufficient to say there is a duty to arrest, right? So I'm happy to accept that under the Rome Statute there is a duty to arrest. But I said when I started that there are conflicting obligations. We also have in this particular instance, and I know most of you have read the judgment, so I won't go into detail, I'm sure there'll be questions, but you also have the host country agreement, right? The host country agreement, by the way, is an international treaty as well, right? It's an international treaty, and there is nothing under international law that suggests that one is superior to the other unless all the parties to this one are also parties to this one. As long as there are differences, then essentially they are equal treaties, right? So there's an obligation on the government of the Republic of South Africa to respect the immunities that are provided for in the host country agreement. I know that the North Gauteng High Court adopted a particular interpretation of the host country agreement, and we can talk about that at question time. So you now have already a conflict of obligation between the Rome Statute, that is the duty to arrest, on the one hand, and the host country agreement. And then you have custom international law, right? I mean, we're all forgetting about custom international law here, which is really the basic fabric of our system. Custom international law imposes an obligation on the government of the Republic of South Africa to respect the immunities of the officials of the Sudanese officials, whether they like them or not, whether they are the devil or not, right? This is what makes the system work. This idea that I read about very often, that because it's these particular crimes, these heinous crimes, there is no immunity, is not true. Right? In 2002, you specifically referred to the arrest warrant case. The court said it didn't matter that it was about genocide. It did not matter that it was about genocide. Immunity still applied as between states. Right? Just a few years ago, the International Court of Justice, in the jurisdictional immunities case, said it doesn't matter. So it kept rejecting these trend arguments about if it is related to these crimes, then there's no immunity. That was rejected by the International Court of Justice. And that's essentially what the arguments that have been made are about, right? They are, because it's these crimes, there is no immunity. That has no basis in law. I wish it had a basis in law, but it doesn't have a basis in law. Not long ago, and I think we can agree that international law is made by states, right? It's not made by law professors who write nice articles, it's made by states, yes? The International Law Commission adopted draft articles, essentially saying 3 people, 3 offices, have absolute immunity. heads of state, heads of government, and ministers of foreign affairs. States welcomed this draft article, right? They welcomed this draft article. Without question. If any question was posed, it was whether or not ministers for foreign affairs and heads of government should also have the same. But in terms of the idea that heads of state are inviolable, this was accepted by essentially everyone. And this rule in custom international law is precisely why you have in the Rome Statute Article 98. It is a recognition that there are other rules out there which may be in conflict with a duty of a state to cooperate. Right. I want to discuss the Security Council resolution because this is seen as a way to go around the custom international law argument. And by the way, those of you who watched the hearing last Monday would have heard Judge Fabricius ask counsel for the applicant if they can pinpoint the provision on which they base the argument that there is no immunity because of the Security Council resolution. And of course, counsel referred to a provision that had absolutely nothing to do with it. Neither counsel for the respondent nor the judges realized that in fact what they were talking about was a completely wrong provision. But so be it. I mean, the decision that was handed down yesterday is based on that reasoning, right? Where nobody knows what provision it is that apparently waives immunity, right? So as I mentioned, in the DRC case, the court, the ICC pretrial chamber, and I must emphasize the pretrial chamber, held that not because there was a duty on all states, because the pretrial chamber recognized that there was no duty on all states, other states were simply urged. Because there was a duty on Sudan to cooperate, so the argument goes, that means there must by definition be an implicit waiver of immunity, right? Because if there's a duty to cooperate, so the argument goes, then cooperation must include waiving the immunities. That also doesn't, I mean, it makes sense, but that's simply not accurate, right? That's simply not accurate. If you go through Security Council resolutions where Security Council intends to deviate from international law, they do so explicitly. The Council does not deviate from international law implicitly. It never has. It's always explicit, and it always sets out the extent of the deviation and the limitations of those deviations. But that's not it. This is not the first time that there was non-cooperation, right? There was non-cooperation in Malawi, Chad did it twice, 3, Nigeria, the DRC, Djibouti, Kenya, right? So we are the 8th, right? In 3 of those cases, the arguments were pretty much about Article 98 and the question of immunities. And the pretrial chamber, of course, disagreed, and it referred these matters, as it should, to the Security Council. If the Security Council felt that its resolution was being misinterpreted by these naughty states that don't want to cooperate, why has it not adopted another resolution saying, by the way, and by the way, it can, by the way, there is no immunity. It hasn't done so, right? It hasn't done so. Those of you who know UN practices know that the prosecutor of the ICC speaks to the Security Council twice a year on this issue. Actually speaks to the Security Council 4 times a year. Twice on this issue, twice on Libya, right? The prosecutor raises the same issue, raises the issue of immunity. Council never once responded by saying, let's adopt a press statement. Let's adopt a presidential statement, something that makes explicit what we had made implicit. If anything, in all of these debates, now before 2010, these debates were always closed, and so we don't have records of them. But after 2010, no, it's actually 2011, sorry. But after 2011, these debates are in the open, so there's a verbatim record of each of these meetings. The only state on the Security Council that has consistently raised the issue of immunity is Russia. No prizes for guessing what their view is. Their view is that Resolution 1593 does not do any of the things that the ICC pretrial chamber says it does. And surely, I mean, they have a right to interpret their own document, right? They say it doesn't do any of that. Right? The only other state to raise the issue of immunity, and they did it once, was Australia, recently when they were in the council. And even they, if you look at their statement very carefully, it's limited to the Article 27 issue, the relationship between the accused, Bashir, Haroon, and so on, against... so it's not, it wiped away immunity as a matter of international law for him. No, that because of Security Council resolution, if he were to appear before the ICC, there would be no immunity. And by the way, I agree with that argument, and I don't think it has anything to do with the Security Council. I think it's simply because, as you mentioned, as a general rule under international law, there is no immunity before international criminal tribunals, right? That only applies as respect to domestic law, to domestic jurisdiction. So the point of all of this is the following. At the international level, there is definitely a conflict of obligations. You've got the Rome Statute, host country agreement, and customary international law. These two say one thing, this says something else, right? If you go to domestic law, and by the way, actually, the South African government applies domestic law, not international law anyways, right? So international law can be useful for interpretative purposes and so on, but it itself is not applied. The arguments have been, and the court in yesterday's judgment is rather careful, and I wonder why, but the argument of the counsel for applicant for why there is no immunity is Section 4.2 of the ICC Implementation Act. A couple of things I want to say about Section 4.2 of the ICC. Well, actually, let me just say, reliance on this section is erroneous, right? Section 4.2 of the Implementation Act has nothing to do with immunity. I say open it and find the word immunity for me in Section 4.2, you will not find it. Let me tell you what it says. Section 4.2 of the Implementation Act says the fact that you're a head of state or you hold one or other position shall not be a defense to a crime. That's a substantive issue. It's not about immunity. Now you might say, well, I mean, why be technical? But if you look at the Rome Statute has both provisions. So Article 27 has an article, paragraph 1, which is about responsibility, this idea that your position cannot be a defense. And then it has another provision which is about immunities. So these are talking about two different things, right? They're talking about two different things. Section 4 is only about, Section 4.2 is only about defense to a crime. It's not about immunity. But more than that, if you look at positive law, right? The Diplomatic Immunities and Privileges Act, of course, is immunity for heads of state. Section 4.1 says a head of state will have the immunity, a head of state within the Republic of South Africa will have the immunity that he's entitled to under customary international law. Right? So it takes that customary international law rule that I discussed, that I said the International Court of Justice guards so jealously, and it incorporates it into domestic law. That's in the Diplomatic Immunities and Privileges Act. That's South African legislation. No one is talking about it. Not even any of the council. But that's another story. Section 6 of the Diplomatic Immunities and Privilege Act provides for immunities of a conference such as the one that was held. Right? Now, it is true that there are some issues with the referencing, but it's in the Diplomatic Immunities and Privileges Act. It provides for those immunities, right? Now, the arguments of counsel with respect to particularly Section 6 was that this particular provision requires the Minister of International Relations and Cooperation to gazette the conference by means of a notice, and the argument by counsel was, well, you can't have a minute competing with an act of parliament, right? In this particular case, the Implementation Act. But of course it ignores settled law, and for this, I mean, for other aspects, I might forgive the North Gauteng High Court, because it's international law, not everyone is an expert in international law, but this is South African constitutional law. I'm no constitutional lawyer, but I know this, right? I'm no constitutional lawyer, but I know that where an act of parliament, right, where an act of parliament provides for some conduct as a form of incorporation, that amounts, for the purposes of Section 2314 of the Constitution, as incorporation, right? But this was completely ignored, and it wasn't even discussed. It wasn't even raised once in the judgment, all right? I want to be fair, and so I'm also going to give the other argument, right? Section 4.2 of the ICC Implementation Act does not apply to this situation. But there is a section that does apply. There is a section, it's Section 10.9 of the Implementation Act, which provides that one's status, so whether you're a head of state, etc., 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 will not be a reason not to arrest and surrender you for the purposes of Section 8 that you referred to. That's the basis. It's not Section 4.2, and this is an important distinction. I'll tell you why it's an important distinction. Because Section 4.2 has language that trumps everything else. It says, despite anything contrary in any other law. But Section 10.9 doesn't have this, right? Which means that, again, you have a conflict between two pieces of legislation. You have a conflict between Section 10.9 of the Implementation Act and various provisions of the Diplomatic Immunities and Privileges Act. And I'm going to leave it there, not try to resolve it, because the only reason why I came here to speak to you was to make a simple point. What you are hearing, that it's all simple, is not true. Thank you very much.
Well, thank you very much, Dira. Let me just say, I thought we should have a quick vote. And the question would be whether al-Bashir should have been allowed into the country and whether he should have been allowed out of the country. But then I thought it would be very good if we have the television cameras, and especially those who come from government departments, we're going to focus on you and put that on YouTube. But we have the tradition at the university now that we have a moment of silence at our graduation ceremonies, and maybe just to ask you for yourself to think, should he have been allowed in, should he have been allowed out? But I think perhaps we will not make it a public request. From my side, we said that we want to move beyond the sound bites. If I have to go back to sound bites, I think perhaps if one looks at one position that was put, it comes very much along the lines of a sports gear advertisement, just do it. The second approach, I would say, comes from a movie, which it's complicated. And then, of course, what is my soundbite on it? It comes from a television series, You Be the Judge, and that's really what we wanted to establish. Let me ask you to join me in thanking our speakers. I think they were erudite, they were informed, articulate, spirited, and most of all, interesting. And I do think it was a privilege for us to host them today and for all of us to be here. So thank you very much to you, and thank you very much.